Well, I will start the recording because I still do record in case somebody wants to watch the recording. I don't think it's as much fun. If you are watching the recording, though, when you get to the quiz part, pretend like it's live and write down questions and answers as fast as you can and try to do it yourself, too. Even though, and you can pause it if you don't have time to write it down, pause it. Live, it's easier to stay focused and to do the quiz part. And, of course, I introduced myself last week. I did work as an attorney from 1979 through 2007, and, of course, I have attended court proceedings with another lawyer after that, just to see if it's still the same old way, and, of course, much of it is. There's more screens, there's more people staring at computer screens than there ever were in 2007, but it's not too much different. This is what it'll look like at my house in a few weeks. And I may not be out on skis, I may be out on snowshoes, which are sort of easier, but I have skis too. Confidentiality is a good topic for Module 2 because it means what it says. What is the difference, do you think? And if you're experienced, don't give it away exactly, but you can chime in, but give others a chance. But what do you think the difference is between sort of ordinary friendship confidentiality and legal confidentiality? And there's no right answer to this.
I'm assuming with legal confidentiality, you can get in trouble for disclosing information.
Okay, get in trouble. So consequences of violation.
Yeah.
Well, what others might be different? How about just bring it back to when we were kids? And I realized I was not kids together with you folks. You weren't in my neighborhood. If you are, and most of my students are younger than me by quite a ways, but some are not that much removed. But we're kids together, and somebody says, "Whatever you do, don't tell mom." You know what happened, and if somebody got injured. And actually bad enough to have to go to the doctor, isn't there a chance I'll have to break the confidentiality? Somebody was riding backwards on their bicycle and whatever. Yeah, at some point, we have to violate the ordinary confidentiality of friendship and say, no, I realize you'd rather I not say, but there's some bad things going down here. I'm going to have to tell somebody, you know, even in a legal context, let's say that you observe a friend backing out of their driveway, and this is a horrible situation. Only lawyers would think about this, but let's put it this way. I bought the latest vehicle I bought has this camera, backup camera. We don't have any little kids living. Well, actually, we do have grandkids, and our neighbors have grandkids that come over sometimes. But in case there are little kids in our neighborhood, we have a backup camera for our newer vehicle. But if somebody you knew backed up over a kid and seriously injured them, broke their leg or something like that, it's a legal matter, but being as they're not a client, you'd have to disclose it, wouldn't you? I was a witness to this. Yeah. The same person, and this is difficult to accept sometimes, but the same person comes in to see the lawyer at the law office where you work, at some point it may have to be disclosed by court order or by discovery if it's a civil case or something like that. But you are not authorized to call somebody up and just say, oh, I feel so bad about this, you know, and I thought I should call somebody. I thought I should call somebody in law enforcement. The lawyer may explain to the client that the sooner the client calls it in to the law enforcement, the more lenient both the law enforcement and the judge will be. But if the client says, no, absolutely, you cannot tell, the lawyer can't tell. And that's a scary responsibility because, of course, the overall rule of confidentiality at that point seems wrong, but you need to think of the broader purpose for all of society, that nobody would see a lawyer and nobody would know the law in specifics to their situation if they were not able to talk confidentially to a lawyer. So it seems like an extreme. Confidentiality in a legal sense seems very extreme. Now we're going to do a little bit of game show, and this is one of my favorite. The Dana Barrett character says this to the kind of a wise guy, alleged scientist. You don't act like a scientist. You seem more like a game show host. So I hope I seem more like a game show host than a professor for the next few minutes. So let's have some fun with this if we can. Who else has authority to impose discipline? Other than these three. So this is a short answer. Yeah, the state's highest court does in addition to A and B. That was not an artfully created question. Actually, A, B, and there should be a D there. Class versus instructor. Answer in 5 seconds to win. Which has authority to regulate licensed attorneys? Go as fast as you can. A, B, or C? Okay, we got enough B's. You win. I'm gonna say class wins because you got the B's. So I'm gonna give you guys the point. UPL in legal ethics is which? See if you can come up with this one fast too. Yeah, as a memory tool, it's B, correct. Very good. I will give you the victory. Class wins. So you win again. Very good. Let's see here. Which is not UPL? This one is kind of subtle. This one is a close call. Because they all seem like they're UPL to some extent. Well, what's wrong with A if it's not UPL? How would you label UPL? I mean, how would you label A? Because it is not UPL. Okay. It's not great diplomacy. I don't, believe it or not, I don't think it's unethical. I think I actually would not be angry at the paralegal for doing it. It depends on what they yelled. Because the obligation of client attorneys should go both ways. If we're working our tails off for them, at least they could show up. For crying out loud, show up. And none of my staff would ever do that unless somebody snotted off. And I realize I didn't put that in the question, but if they snot off to my employee and say, "Well, I just didn't want to come," I had other stuff going on, I could see raising the voice a bit. So again, I would probably be lenient on that employee if the client was rude to the employee, put it that way. Yeah, and I understand that. I understand you're all in favor of politeness, and that's not typically the role of the paralegal. I will agree with you. That's not the best diplomacy, undiplomatic, but I would not discipline this person if it was like most circumstances. I would be on the paralegal side because, and like I say, I'm sort of going by the average or whatever. None of my employees would have yelled unless there was ample justification. We have worked so hard to get prepared. It happens sometimes, and generally it's with a client who has a bad attitude. If they called, if they were apologetic, fine. But just not showing up, bunk. Hey, have your sister call, have your brother call, have your mom call or something. Don't just not show up. Yes, and it happens. Yeah, it's embarrassing and bad, and the lawyer gets it's stinking bad. Put it that way. Yeah, it definitely happens. And like I say, in some cases there is a lack of respect for the court system and the lawyer and whatever. And which can the lawyer reveal? Yeah, this is kind of awkward. Here's a situation where I got yelled at. Somebody in the real estate business says, "It's a public record. You're going to make me look it up. Why don't you just tell me?" And I said, "I can't. The client does not want me to reveal this. I realize it's a public record, but you'll have to look it up." Actually, this is an exception, isn't it? Sort of forgot. Yeah, you're right. Yeah, this is B is actually correct. Why is B correct, whereas alternate B would be how he killed his boss. Can't be revealed. Plans can. Yeah, you're right. I'm gonna give a big win. I'm gonna give 2 points to the class because you remembered something I forgot. So B is correct. The lawyer can reveal B. How he killed his boss can't be revealed, but plans to kill. So I underline plans. So future one. Now I was involved in foiling an attempt to kill people at the courthouse. Not actually the courthouse, but the courthouse annex. But that was not a client. That was actually an opponent. My client's opponent made a big threat, and they checked it out, and they got a warrant, and he had bomb-making apparatus in his car. And I asked them to, of course, I knew the people that worked there in that annex, of course, and so I asked that they have better security for that area. But that was not a client. That was not confidential as to me. You know, my client was happy that I revealed this when I found it out. What's strange is that this person who was not all right in the head was did not threaten me, even though I was the meanest. I was probably very mean to this person in terms of verbally, you know, accusing him of such on the witness stand and so on, but he was not threatening to me because he sort of feared me a little bit, I suppose. But he was, anybody who was nice, the least bit nice, he threatened them. Very, you know, scary person in a way. And one other man that, you know, and I guess he was more, he would back down if another man confronted him, another man that was in the court system sort of confronted him verbally, and he sort of backed down. But anybody who was sweet and nice to him, he was threatening. Which is the attorney required to reveal to court? You cannot, you probably have to do this, but my way around B, because I don't like revealing anything, is just to say, if I'm handling the trial, basically what I do is I have them testify as a narrative. I can't ask the question, but that, in a roundabout way, that reveals to any good judge that I don't support what they're saying. Give your name and tell your story. That's all I can ask. Well, if I do that in open court, the judge is going to look over at me like, this is not proper, but it is proper if the lawyer thinks and is quite sure that the client is not going to tell the truth. So then, of course, I tell the client that. I said, the judge is going to know you're lying because I can't ask any questions. And then normally the client would always back down. Okay. Microsoft Word encryption is not helpful at all for confidentiality, somewhat helpful, or totally secure. What do you think? And I guess I can give you a hint, but if you try it, don't lose your password, but there is a way around it that you can look up on the web. But here's what it does. It stops the honest opponent from reading it. So let's say that you send an email and you inadvertently, by accident, you send it in a reply all, a separate message only to the client, okay? And this is where it would have helped to encrypt the Microsoft Word, and then you, instead of telling what the lawyer wants the client to know in the message itself, you include it in an encrypted attachment. So an honest opponent will not attempt to unencrypt. Do you see where I'm coming from? They know the purpose of this. So an honest opponent. So you have protected the client against an honest attorney on the other side. Obviously, you haven't protected the client against a dishonest person that would say, well, we're going to find a way around, you know, we're going to turn the document into something else, and then we're going to unencrypt it this way or so on. They should know that if they have to use a trick way to unencrypt it, that they're trying to find something that wasn't intended for them. If it was intended for them, we would have telephoned in the password, wouldn't we? And we may not have even telephoned the client with it. We may have said, well, we're going to send you a confidential message, and here's the password, and actually handed it to the client in person, or maybe snail mailed it. Does that make sense? Yeah. But Tanya, what I'm saying is, Tanya is saying, well, if they don't have if they do not know or do know how to unencrypt it, if they have the password, of course they can unencrypt it. But what I'm saying is, even if the person doesn't have the password, you can beat Microsoft without being a supreme expert. But an honest person will not use that. It's elaborate enough that it gives notice that you're doing something wrong. Put it that way. Courts and legislatures protect most people. It's rules against requiring testimony about legal confidences, secrets, and advice. Protect these people. This is interesting. Does this protect both clients and lawyers? I would say no, it doesn't. Does it protect lawyers at all? No. Legal confidentiality just protects clients. I would have liked to have double confidentiality. That would have been nice. in some instances because I really didn't want the client to retail my specific advice to other people who haven't paid for it and will misapply it. I mean, it would have been nice, but it just doesn't exist. So what I tell clients, they can tell others. Does that make sense? I mean, so if I want to, make something confidential on my site, I'd have to have a contract, and I would really think on legal ethics, I would have to have a darn good reason for it. I'll give you an example, but lawyers typically do not do this. Lawyers will send written advice on estate planning, probate, various other things, family law, and they know that somebody else in the family of their client could apply it rightly or wrongly, but I've never heard of, or hardly ever have I heard lawyers that tried to bind the client not to tell. Because there is some damage to the public from the fact that clients will take and run with the advice and say, well, my lawyer said to go ahead this way. Well, no, the lawyer didn't exactly say that. Or my client said that trees interfere with radar, so you should always fight a speeding ticket if there's trees there. No, that's not what the lawyer said. The lawyer said there was interference in your case with the radar, and we had outside witnesses that said you were actually proceeding very slowly, slower than other traffic. And the radar machine was not set up correctly. That's what the lawyer actually said, but the client will repeat what they thought they heard. Oh, you should fight every speeding ticket. No, that's not what the lawyer said. Or some of the other cases, insurance companies never pay voluntarily for anything. No, the lawyer didn't say that. You should never take their first offer. The lawyer didn't even say that. Introductions. Remember to take advantage of Lexis as a research system. It's not a database. It's a cross-reference system. So I want you to be playing with power. Okay. The original purpose of the attorney-client privilege is what? What do you think? Based on Old English law, I would call it. Maybe even Roman law, I don't know. Yeah, B is correct. People who can consult a lawyer with confidence will learn to comply with laws. And I did see this happen quite often. There's lots of names I don't see in the paper and haven't seen for a decade or a couple of decades that were in the paper a lot years ago. They used to get in a lot of difficulty, and they don't now. Their lawyers gave them good advice, and that helped. But the lawyer had to gain their confidence by doing something for them, of course. Find official, actual, enforceable rules, case decisions that relate to the rules. Lexis is best. Why? Because you can scroll down to cases when you find a rule. and I think we've talked about some of the whys. You don't want to tax your patients too much because, of course, this particular session is not earning attendance points. But to find cases about breach of confidentiality, pick a state and go to rules of court. So go to Lexis, pick a state. Several goals are met by drilling down using the tables of contents. You learn thoroughness. You see related laws and rules. It's slow at first, but it keeps speeding you up. It's additive. Your memory system, your recall system actually is storing up information as you drill down and skim, and you don't even know you're doing it. Learn the structure and the headings. Again, you pick up things you didn't know you wanted to know. So you go to Florida, for instance, then local, state, and federal court rules, and then here's rules regulating the Florida bar. And these are not the enforcement rules. The enforcement rules are like the rules of procedure that have to be followed to discipline lawyers. That's not what we want. We don't want the procedural rules. You have to look at sometimes you end up looking at both and you say, well, this is all procedural. This doesn't tell what's right and wrong. So sometimes you have to hunt around a little bit. In this case, bylaws, let's see. In this case, rules of professional conduct would be it. This one would be the procedural rules in Florida. What do they have to do to discipline a lawyer? What procedures? But this one would be the correct one to find the actual rules. And you're going to find that other than the number system, frequently they're very similar to the ABA rules because many states find that the ABA basically summarized rules that were very old rules. And as they summarized them and worded them, many states have not found better ways to do it. So these are not super different than what you're used to from Module 1. To prevent a client from committing a crime, and that's what we talked about. So already committed, no. Planning, yes. Don't reveal. Okay. But these are must reveals. Prevent death or substantially bodily harm or prevent a crime. And then may, and you have to use the rules of grammar and word usage, of course. May means maybe, basically. May not have to. May or may not. Some of the may or may nots get kind of difficult. So look at those and then look at the case decisions underneath. So you look at the case decisions and then to get into a little more depth, you just click on the blue links. So confidentiality, you do want to show the site and then the questions and comments, okay? Give me a moment here, okay? Okay, I'm back. Again, scroll down in Lexis, pick a state. Good question. My suggestion would be focus on your home state. If your home state has no interesting cases, go to a neighboring state. How's that? It's same thing with statutes. You can go to statutes. So if you wanted to review unauthorized practice of law, that would be in statutes, typically not rules. And we're not going to go over UPL again. We already talked about that fairly thoroughly. I was answering a question about do we need to stay within a specific state? No, not necessarily, I was saying so. But I would start with home state because the more you get used to your home state, the better off you are in terms of being able to find things. People say, well, I'm just finding junk on random searches. I realize that. But if you get used to your state's statute book and your state's books of rules, and I realize you don't see them as books, but imagine them as sets of books because they are in your state's law library as books. Sets of books, color-coded sets of books. So your statutes are a color-coded set of books. Your rules are typically issued both as color-coded books and as paperbacks, as well as electronic. And you get used to those volumes, searching them electronically and being able to know the table of contents. The whole structure of your state's law starts to make sense to you. And you say, hey, there's certain things that aren't covered. My state statutes are not very thorough as far as military reservations, except for some National Guard stuff. Oh, that's because a lot of military stuff is federal. Okay, I get it. And then you start to figure out, well, I looked on federal for family law, and I pretty much found some interstate stuff where children get snatched across state lines, but I didn't find any basic family law. And then I looked in my state. Well, all the basic family law is state law. Okay, I get it. So all of a sudden you become much faster researcher. You sort of can put your finger on basics pretty fast, and you can double check sites and find related things. So you want to do your readings. Try to work your readings into the written assignment to the extent that you can. It helps you learn your readings, and it obviously helps you gain points in the written assignment for good reasons. The good reasons are basically you're learning to make a habit of citing authority. So it isn't just you giving a memorized answer, it's you giving useful information that's cited correctly. Lawyers don't like admitting that they didn't know something, but they will admit that they appreciated you getting it cited for them so that if they get asked in court, they can say, well, that's not in that rule, Your Honor, that's in this other rule. No, I think that's in the next statute with a little different number. I think that's in, 169.745, not 744. And they've got it right in front of them, and the other lawyer doesn't have a clue on where it is. They just know they know it. Does that make sense to you folks? The better prepared lawyer may lose, but being even slightly better prepared makes their life better. You may win because of the facts. I do tend to think that, in judge trials or jury trials, and I handled a lot of judge trials and substantial number of jury trials, but I do tend to think that facts win. But even when the facts are one-sided and justice is totally done, whatever, whether the lawyer won and should have won or lost and should have lost, being better prepared and not looking like a turkey makes their life better, makes it better for them to have something called a weekend or partial weekends. You know, I mean, I used to come in on Saturday morning, so, and I did a little bit of work, and one of my kids and I would clean, whatever, fine, but because I had good employees, then I could take the rest of the day off frequently and take all day Sunday off, get back, work Monday because I knew things would be in order. You know where I'm coming from? If your life is better, you want to keep that employee as much as possible. Employees that are valuable are a lifesaver. Even to a totally organized lawyer, I dealt with a totally organized lawyer one time who did only collections and incredibly organized. But even that lawyer had employees, and that impressed me. I thought that lawyer could have operated without employees, but still wanted somebody else to proofread and assist with documentation. But you could talk to this lawyer for 10 minutes on the phone, and the lawyer would dictate into a tape recorder like 5 different things to do, including cover letters. It was almost creepy efficient, but it was neat. But even that lawyer had employees, and of course, the employee had to be, for a lawyer that efficient, I'm sure they had to be very exacting. And if the lawyer said they were supposed to do a certain action, they had to use the correct form in the correct way and the correct statute, et cetera, et cetera. Even though that lawyer would have memorized the statutes used, you still want, hopefully, if you hire somebody at the paralegal level, even that lawyer should want the employee to look up the statute, make sure that it's the latest statute on the topic, and see if there's any new case decisions as they scroll down in Lexis or one of the competitors of Lexis, like Fastcase, and make sure that there are no case decisions that impact what's going on. So take a look at all of these. I will look at them again and make sure they're all accessible. Sometimes the links decay, no longer work. I will check links. Here's some additional resources. And of course, confidential information session, let me know if you are missing anything. Let's see here. I guess I got 2 more slides here. So what are you doing? 5 slides. Is this supposed to be just, you know me a little bit, I think especially those of you who are here in person, you know me well enough now. Do I want a casual set of slides with no citations? Or something you would want to give the lawyer? or show during an interview. Yeah. Yeah, you're correct. I was just at a faculty meeting. We were talking to outside academic people, outside Rasmussen, and what do I like about working for Rasmussen was one of the questions that was interesting. And I said, well, I couldn't come up with a real polite way to say this, but I says, my students are adults and they have good BS detectors. So if I just said, well, anything just casual would be good enough, I think my students are adults who know what it takes in the working world to advance. So if I went a little bit slack, I think you'd call me on it. I hope you would. I think that if an assignment does not advance you, even if you think it's of some value, but it's not of too much value to you because of your experience or prior education, go ahead and ask me to come up with some other research that you can throw into it, okay? If it doesn't advance you, I still want you to do it, but I want you to add something to it and I will help you. If it does not advance you personally, let's talk, okay? Because we're not here to just prove that you already know stuff. You're all people who know things. You're all smart. You can all figure out things. You can do research later or whatever, but the intensive time of college education, let's get it done now, because even though you're busy now, it's going to be even busier when you move into higher level work, such as working for an attorney. Not everybody's going to work for a supervising attorney. Some people are going to do other legally related jobs, but when you get into the more intense work, you're going to say, oh golly, I wish I'd have paid more attention during school because now everything is such a rush. Okay? The speed at which we need to do things, frankly, I mean, that kind of surprised me many years ago when I started being a lawyer, just the fact that you have to deal with so much so fast. That was kind of a surprise. It's not very leisurely. So what do you want to aim at? My suggestion would be your first draft, try to get one of those two. So I would say most folks do a first draft, basic explanation somewhere in there. The first draft, do some formatting, don't overdo it. Get a first draft up there with it. Then go through it and try to up your game as time allows on either one, okay, on any of these. That's what we have to do in the law office a lot of times. Sometimes you do have to get something ready. The lawyer needs to come up with an advice letter, and you don't necessarily get to be completely thorough on everything. The lawyer is going to have to fill in gaps. You provide your report, the lawyer then needs to complete it, and so on. It's not always you being able to do a complete job every time. But as time allows, you should be able to ask the attorney and say, well, here's my first draft. What else do you want? In school, you end up frequently asking me, you say, you know, I really didn't know what you meant by on-target primary legal sources. Can you help me with that? go ahead and ask me for help. That's fine. Or use tutoring, or use Lexis help. Don't be embarrassed. I hope you wouldn't in the working world. I hope you will force yourself to be assertive in the working world. If the lawyer asks for primary targeted sources and you're not sure what they mean, ask. But between the time the lawyer signs it and the time you can get back in and see the lawyer again, maybe a gap. So in the working world, I would do something adequate rather than just wait. And then ask one or two questions. You know, they say professional and appearance, you know, are you crazy? You only gave me a short time to do that. Well, you can't really, that's kind of undiplomatic to tell the lawyer that. Unless you've been working for the same lawyer for 15 years, you maybe want to say, you know, I had to put something basic together and I focused on content. Can I have a little bit more time to make it look nice? You know, that's a legitimate question. Comments, questions about this? This is our last slide. I'm going to pause. Excuse me, I was off recording for a bit, but if I were a student, I would do a first draft so that if difficulties come in my life, I would have something to turn in. And then to the extent possible, I would do a final draft and I would try to get to this top level. You may turn in both. You don't have to. You may turn in both, but many students work on a first draft, then budget the time to do a better one. The other thing you do when you budget your time to do a final draft, set a timer if you feel like you're somewhat of a, I don't want to use psychological terms or whatever, but if you think you overdo it, budget time for final. I have students, former students all over the country who set oven timers, you know, and of course I realize that you're thinking, well, it must be older students in their 50s or whatever. Well, not always. Some younger students will set an oven timer because they have the same attitude that they don't like their first draft at all. Well, fine, but set an oven timer or an electronic timer, and when the thing goes off, turn in what you got. Okay? So what I don't want is I don't want those students who tend to the perfectionist idea to hold on to their work. Don't hold on to your work till the following Tuesday in hopes that you can make it perfect, that you'll get inspiration. Turn it in on time. By the same token, if you tend to be a person who feels like you need to step it up and you need to be more of a detailed person, and there are a few. If you feel like you need to be more of a detailed person, ignore the advice that I just gave, or adapt it, whatever. Does that make sense? I cannot give everyone the same advice. Some students maybe need to set, well, actually it would still work, come to think of it. If you think if all the teachers are being unfair because they all wanted you to do more, it's possible that if it's more than one faculty member, if three different faculty members all feel like you could do more, you're not being thorough, then set a timer and do more. You know, And in that case, though, when the timer is running, hopefully you can get a family member to tell everybody else or keep everybody else out of your hair for a full hour, okay? And I realize that's hard for many of my students. Hardly any of my students are independently wealthy and have household help available to show up. And, you know, actually, there are a few of my students that are quite well off, I guess. But typically, most people who go to a career college are not going because they're independently wealthy and are doing this as a sort of a hobby. Okay. And you may have to ask people that you don't like to ask for help, people with names like mom and dad, to watch the kids for 1 hour, or sister, brother, somebody, you know, husband, wife, best friend. Somebody needs to watch those kids for an hour sometimes so you can fully concentrate. It helps. I do have students that have done that, and they say, well, it's annoying, but if I want to get to the next level, I have to be able to do this focused work. It's very hard to focus. And I do have sympathy. I mean, I never forgot this. We started out at a law office. I was in the front office. My wife was at the desk, and we had a playpen in back. Somebody came in and said, is this a law office or a daycare center? And my wife says, it's both. Have a chair. I got a kick out of that. But I had very soon had another employee, so who would take turns with my wife of being at the front desk and stuff. So, but yeah, so I do have sympathy. Whoever was on the phone did not hold the baby.